Good afternoon and welcome to the Nebraska Court Improvement Project webinar, Qualified Expert Witnesses in Indian Child Welfare Cases. My name is Teresa Cusick and I'm a project specialist with CIP. This webinar has been approved for 1 hour of CLE credit, and the activity number will be put in the chat at the end of the webinar. And if we have time at the end of the webinar, we'll try to answer any questions that have been put into the Q&A box. Our presenter for today is Alexis Zendejas. Alexis is an enrolled citizen of the Omaha Tribe of Nebraska and is the ICWA and Children and Family Services attorney for her tribe. She has worked with tribes and indigenous populations for over 10 years. Her work in Indian country has been focused on family and juvenile law, as well as tribal, federal, and state relations. She has successfully argued on behalf of her tribe and ICWA in the Iowa Supreme Court. Alexis graduated from Brigham Young University in 2016 and earned her JD and certificate in Indigenous Law and Policy from the University of Arizona James E. Rogers College of Law in 2019. Alexis, I'll turn things over to you.
Thank you. I'm going to go ahead and try and share my screen. I will say that, I will say that I have a lot to get through, and I will try and answer questions at the end. But if it goes over the hour, I am happy to stay behind, or stay longer, I should say. Okay. Are we good to see everything? Okay, thanks, Teresa. I appreciate it. So like Teresa said, I have been working for the Omaha Tribe of Nebraska for 3.5 years as their specific counsel for Indian child welfare. I have practiced in 15 states. However, most of our cases for the Omaha Tribe are in the state of Nebraska and the state of Iowa. So let's see. There we go. Okay. I will put a little bit of a language disclaimer on here. The term Indian, I will use frequently. It is a legal term of art, so that's why I will use it. I will also be using that interchangeably with the term Indigenous and with Native American. I will say, however, if you do know someone who is tribally affiliated, the general rule is to call that person by their tribal affiliation. So, for example, I identify as an Omaha woman, and if that's unknown, then the commonly accepted and preferred term is Indigenous. But for the purposes of what we're doing today, Indian is a legal term of art, so I will be using that terminology. So here's the outline that we're going to be going through today. And like I said, it's a lot to cover. So we'll just get started. I wanted to do a brief history of ICWA just because I think it is unfair to cover a topic or an issue in ICWA without understanding the purpose behind it. So the Indian Child Welfare Act was enacted by Congress in 1978. Congress wanted to remedy the disparity and disproportionality of Indian children in the child welfare system. They performed congressional studies and they determined, and I apologize, I'm going to use a Taylor Swift lyric. They determined that it's me, hi, I'm the problem. The federal government realized that a lot of the policies that they have enacted throughout 200 years had affected detrimentally the Indian family. And so the purpose of the Indian Child Welfare Act is to protect the best interest of the Indian children and to promote the stability and security of Indian tribes and families by the establishment of minimum federal standards, this is directly from the statute, for the removal of Indian children and placement of such children. In 2016, there were federal guidelines that were put out by the Bureau of Indian Affairs, and as recently as 2023 in a Nebraska Supreme Court case in Ray Manuel C. and Mateo S., the Nebraska Supreme Court said that those guidelines must be followed by Nebraska courts. Some of the biggest federal policies that were really the issue that Congress found started in the assimilation era. Now, there's 100 or so years or 200 years more of federal Indian law and policy that has directly impacted the family. But what the federal government and what Congress saw was the biggest issue was Indian boarding schools. If you have a chance to read Neil Gorsuch's concurring opinion in the latest ICWA Supreme Court case, Brackeen v. Holland, please do so. It gives a really in-depth, you could teach a federal Indian law class just based off of his concurring opinion. So if you would like to learn more, that is a source that I will direct you to. But the purpose of Indian boarding schools was, according to the federal government and the propaganda that they put out, was to Christianize, educate, and give the Indian vocation. This federal policy came out during the assimilation era. Boarding schools started around the 1860s. I believe 1869 was when Carlisle Indian School which is the first Indian boarding school, was when kids started to ingress in that school. It was created by Captain Richard Pratt. And so the Christianize, educate, give them a vocation were the threefold, mission of these boarding schools. However, what Captain Richard Pratt, the father of Indian boarding schools, claimed was that it was to kill the Indian and save the man or save the child. It was an effort to assimilate children into westernized culture, and it had a big impact on Indian children and Indian families. This is a picture of an Indian child before he entered into the boarding school and then after. So big impacts are that there's a loss of their indigenous language. And not only is there a loss of their indigenous language, but there is corporal punishment involved if the children spoke their native tongue. And there's a loss of knowledge and traditions, customs, ceremonies. And one of the biggest impacts is that the social familial structure of the tribe and of children from tribal families and tribal backgrounds was completely lost. You go from having a family, mom, dad, grandma, grandpa, aunts and uncles, whatever your familial structure is, and you go into a militarized boarding school system where they're given English names. There's a high mortality rate. They died from tuberculosis, abuse, neglect. There was hardly any medical care on these campuses. And the adults in their life that were supposed to show them, or that would have shown them what a family was supposed to be like, a family was supposed to act like, were generally abusive. And as we see this from Secretary Holland's report on boarding schools, I believe from 2022, from the summer of 2022. So basically, you're taken from a family setting and put into a militarized camp. And this happened forcibly. And if it wasn't forcibly, it was under situations of duress where the kids were in families that had fallen on hard times because of these government policies. And families, in order to have these kids at least have a meal, would send them to boarding school. And this would be as early as the age of 3 or 4. So very, very important developmental years were spent in these boarding schools from as early as, like I said, 3 or 4 until they reached adulthood. I will say as well that the last boarding school that closed, I believe, closed in 1996, a boarding school that was operated by either a church or the government. So I'll divulge my age. I was 4 years old when the last one, and so I would have been old enough that that policy of forced entry into boarding schools still remained. I would have been forced into boarding school, and I imagine that a lot of us on this webinar would be as well. Additional federal policies that led to ICWA. There's really a lot, and I have a theory that every policy that the federal government enacted impacted the family. I mean, but these are the big ones that I wanted to touch on. The Indian Adoption Project, it was a federal program, that was supported by the BIA, so the Bureau of Indian Affairs, that promoted removal and adoption of Indian children to non-Indian families. And the Indian Adoption Project started in, I believe, the mid-20th century, and children were literally taken from their families without notice and without due process. Another one is the Indian Relocation Act. Actually, I am a product of the Indian Relocation Act, or I should say that my father is, and therefore I am transitionally. But it was a program that the intent was to encourage Native Americans to leave Indian reservations, and they promised a job, they promised housing, so that they would assimilate into the general population. The Indian Relocation Act of 1956 occurred during a federal era of Indian law and policy that's called the termination era, where the federal government was determined to dissolve tribal governments and dissolve any tribal sovereignty. So this was their attempt at doing that, so they would disperse people from the reservation and get them to assimilate into the general population. What Congress, I don't believe, took into account was that it was the 50s. Racism was outright. It was blatant, and so there was still a lot of issues with housing. The jobs that they were able to get Indigenous peoples in the 50s were not high-paying jobs; they're more laborious. And so we have this introduction of this term called the urban Indian. And you have higher rates of poverty in inner cities, which directly affects the Indian Child Welfare Act and how many kids, especially in the 70s, were in the child welfare system. Something that also led to the Indian Child Welfare Act was the Self-Determination and Education Assistance Act of 1975. The federal government kind of realized, hey, this termination era isn't really working. So we've entered into the self-determination era, where they reestablished tribal governments and this idea of sovereignty, as well as the trust relationship and the political relationship between tribes and federal and state governments, which directly affects the Indian Child Welfare Act and those children that are subject to the Indian Child Welfare Act in their child welfare cases. So where are we at now with the Indian Child Welfare Act? These numbers are still not great. We are at, I got these numbers from the Department of Health and Human Services. 4% of child welfare cases involve Indian children, but Indian children are only 1% of the population in the state, of children in the state. 45% of Indigenous children are placed in non-relative care. And Indian children stay in care on average 52 days longer than non-Indigenous children. And Nebraska has the 6th highest disproportionality rate for Indigenous children in the United States. So 6th place, I don't care how you slice it, isn't really great. So that's why it's really important to understand why this extra level, this qualified expert witness, is necessary when it involves Indian children, because of the disparity that has existed and still currently exists in our state. The statute, these are the references that we're going to go over today. If you'd like to look them up word for word, I have them kind of dispersed throughout the PowerPoint. But these are the federal and Nebraska ICWA statutes that we're going to be going over that involve qualified expert witnesses. I wanted to go over the burden of proof as well. So what is the burden of proof? I'll just go ahead and read this. No foster care placement may be ordered in such proceedings in the absence of a determination supported by clear and convincing evidence, including testimony of qualified expert witnesses, that the continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. That's for protective custody. For termination of parental rights, or TPR, no termination of parental rights may be ordered in such proceeding in the absence of a determination supported by evidence beyond a reasonable doubt, including testimony of qualified expert witnesses, that the continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical damage. So for both protective custody and termination of parental rights, your evidentiary standards include having a qualified expert witness. Not having a qualified expert witness means that you have not met your burden of proof. So who has this burden of proof? The state does. A qualified expert witness, and I will say this is for child welfare proceedings, because the Indian Child Welfare Act does apply to private adoptions as well as private guardianships. So I'm going to speak just to child welfare cases or 3A petitions in the state of Nebraska. So who has it? The state has it. Qualified expert witness is the state's witness. I will say that that is not the tribe's burden to provide a qualified expert witness, or to meet that burden, I should say. The tribe should be involved, or the state should attempt to involve the tribe in locating a qualified expert witness. And we'll go into that as well a little bit, because I do touch on that. The tribe should also not be prepping the witness for the state. And like I said, the BIA, so the Bureau of Indian Affairs regulations, and the Nebraska Indian Child Welfare Act do require working with the tribes to locate QEWs. And I do want to note that qualified expert witnesses should also be compensated for their time and mileage, just as any other expert witness would be compensated for their time and mileage. Can work something out with that qualified expert witness, but the tribe has in times past paid for the qualified expert witness, because the qualified expert witness has that relationship with the tribe, but that should not be something that the tribe does. It is more of a courtesy that the tribe does that. But like I said, it is the state's burden. What happens if you haven't met that burden? And I do put this like disclaimer here in the bottom, ICWA according to Alexis. And I say that because there's not, I haven't found any case law that says this. This is just from the plain reading of the statute, both the Nebraska and the federal statute. So I do want to put that disclaimer out there, but it is my understanding that if there is not a qualified expert witness testimony, or if the qualified expert witness testimony is contrary to protective custody, only the protective custody should be dismissed, and the child should be returned to the parent or custodian. And the 3A case, the petition can still continue without refiling, but the county attorney can refile on the protective custody. So who is a qualified expert witness? So we'll look to the federal regulations. The statute does not outrightly identify or define who a qualified expert witness is, but the regulations and the BIA guidelines say that at least a qualified expert witness should have knowledge of prevailing social and cultural standards of the tribe, and should not be the social worker regularly assigned to the case. Qualified expert witnesses should be someone who can provide that culturally informed opinion, and an outside opinion to the court regarding whether the continued custody by the parent is likely to result in serious emotional or physical harm to the child. In addition, the qualified expert witness should have specific knowledge of the prevailing social and cultural standards of the Indian child's tribe. In the passing of the Indian Child Welfare Act, Congress wanted to make sure that Indian children and Indian child welfare determinations were not based, and I'm going to quote the legislative history here, that Indian child welfare determinations are not based on white middle class standards, which in many cases foreclose placement with an Indian family. So Congress recognized that the states had failed previously to recognize the essential tribal relations of Indian people and the cultural and social standards. prevailing in the Indian communities and families. So accordingly, the expert testimony presented to state court should reflect and be informed of those cultural and social standards. This ensures that relevant cultural information is provided to the court and that the expert testimony is contextualized within the tribe's social and cultural standards. Thus, the question of whether the continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical harm should be examined in the context of the prevailing cultural social standards of the Indian child's tribe. So I will also say that the rule doesn't strictly limit that the QEW needs to have tribal social and cultural standards. However, there are specific exceptions to that, and it would contravene the purposes of ICWA to not believe that it's relevant. That exception is if the circumstances are plainly irrelevant. And like I said, we'll go into that more because there is a Nebraska appellate statute, or sorry, not Nebraska appellate court decision that has come out recently to address that. So those are the federal regulations. This is the Nebraska state statute that provides a more in-depth detail as to what Nebraska would like to see the qualified expert witnesses be. It is also in descending priority order. So A being the most prevalent and given the most priority, and E being the least priority. So this is not exact wording of the statute. This is a summation of the statute, but A is a member of the Indian child's tribe. B is a member of another tribe that is recognized as a qualified expert witness. C, a layperson with substantial experience of children and family services to Indians and extensive knowledge of social and cultural standards. D is a professional with substantial education and experience in their specialty that demonstrates the knowledge of social and cultural standards. And then E is any other professional having substantial education in the area of his or her specialty. And put little asterisks here because it is the only subsection of this statute that does not include knowledge of social or cultural standards. So this is the case that was within the last 6 months, I believe, in the interest of Cameron L. and David L. versus Clarissa L. It has a bunch of different issues regarding that specific case. It also has a couple of issues regarding the Indian Child Welfare Act, but I'm just going to focus on the qualified expert witness issue that was addressed in this case. So Clarissa L. is mom, and her parental rights were being terminated. And I believe the mom's attorney appealed, stating the following arguments. One, stating that there wasn't that the qualified expert witness wasn't a qualified expert witness. And so the qualified expert witness in this case was a mental health professional, had 10 years of experience in education, 10% of the clientele that this QEW had were ICWA applicable. And then they also state in the opinion that, there should be a close quote there, that they were a certified ICWA expert for Lancaster County juvenile courts. Another issue with the qualified expert witness in this case that the mom argued was that there wasn't enough interaction or knowledge of the family for the QEW testimony to be considered a QEW testimony. The mother's attorney argued that there was no personal contact, and in the facts, the court did recognize that there was access to pleadings and court records, so that the QEW did have access to pleadings and court records. And then the biggest issue that I see regarding QEWs was the question on whether or not it was necessary for the QEW to have prevailing social and cultural standards. I believe the facts of this case were that the QEW had said that their grandmother was Pasquayaki and that they had ties to a Sioux Nation by an aunt through marriage. Just kind of laying it out. So I'm going to go point by point as well. So as to the QEWs credentials, I think everyone kind of conceded to the mental health professional 10 years experience. I don't think that was really a question of whether or not she had credentials. I do want to address this certified ICWA expert for Lancaster County. In my opinion, I believe it. I don't think that the court addressed this. This is just something that I saw in the opinion, or at least laid out in the facts of the opinion, was that they referenced this QEW as someone who is certified ICWA expert for Lancaster County. So I believe that having a state certify an ICWA expert contradicts the purposes of ICWA and the encouragement to locate the tribe and to communicate with the tribe and the BIA to find a qualified expert witness within the first few preferences of the Nebraska Indian Child Welfare Act. I will say that the opinion doesn't mention if this was a last resort or if this QEW was a last resort, what other avenues the state took to locate an Indian child welfare or a QEW within ICWA priority preferences of that Nebraska statute. It doesn't mention that. To me, it just seems outside the purview of the state Department of Health and Human Services, the county attorneys, or even the judiciary to determine matters of cultural value rather than matters of law. So I will say that there is a difference between having a list of QEWs already prepared that you have discussed with tribes versus a state organization or entity creating and certifying someone to be a QEW. So interactions and knowledge of the family, that issue, I do think that the court in this matter, maybe, I think, well, they relied on precedent because it is normal to have access to pleadings and to court records. It is best practice to have that personal knowledge and contact with the family. I do think that is something that the state of Nebraska can do better at. And I think this is not just the state of Nebraska. I will say this is more of a larger ICWA issue. Can be better at familiarizing the qualified expert witness to the case, including access to documentation and witness prep. That may include allowing them time with the family or however the case may be. I will say that something that I've been working with some DHHS Native American program on some ICWA compliance ICWA compliance projects, and we found that North Dakota has a qualified expert witness program that I think we could work on researching more, because it is a tribal and a state initiative, a collaboration where they identify a qualified expert witness at the onset of the case, and the qualified expert witness works with the family throughout the duration of the case in the event that a QEW is needed for termination of parental rights. That is a long time down the road, though. And like I said, I think the biggest question in this case is whether or not QEW is required to have knowledge or understanding of prevailing social and cultural standards. And I think that not having the QEW have those prevailing social and cultural standards contradicts the purposes and intents of ICWA. I think that there are portions of the opinion that are somewhat suspect and would be worth revisiting in the future if the case presents itself, or as the opinion states, discussing with the legislature and updating the statute to reflect the 2016 guidelines. So with this, though, I will say, according to the guidelines, the only exception for no social and cultural knowledge is when the social cultural aspect is plainly irrelevant. Then we must look to what is plainly irrelevant for a QEW testimony to disqualify the need for social cultural knowledge. The guidelines give an example of sexual abuse, which I don't believe was the case in this, was the case in Clarissa L. But for the state to meet the burden of proof, there has to be a demonstrated correlation. This is directly from the guidelines, a demonstrated correlation between the conditions of the home and the threat to the specific child's emotional or physical well-being. So the rule prohibits relying on any factors listed in section 23.121 of the federal regulations, which include, and those prohibitions are poverty, isolation, single parenthood, the custodian's age, crowded or inadequate housing, substance abuse, or non-conforming social behavior. And so there has to be that causal relationship between those and the threat to serious physical and emotional harm, which speaks directly to what a qualified expert witness testimony addresses and the need for cultural knowledge to meet the burden of proof, as there are not plainly irrelevant circumstances. So all this to say, okay, well, you're telling me that I need a qualified expert witness that has social and cultural knowledge. How do we find someone that meets those higher priorities in the Nebraska Indian Child Welfare Act? So I've come up with some ideas, and some of them is required by the Nebraska Indian Child Welfare Act, which is including, working with the Indian Child's Tribe. There should be contact with the ICWA specialist, attorney, or representative. I understand that there are cases where that is not possible or that is hard to do. And so working with the Bureau of Indian Affairs to help identify tribal agents, to help identify other tribes that could potentially have that social cultural knowledge that may pertain or be similar enough to the tribe that you're trying to work with, to help identify a qualified expert witness. I will say the Nebraska Indian Child Welfare Coalition does a really good job of reaching out and has a really good network to be able to help identify a qualified expert witness that will be higher up on the priority list as is listed in the Nebraska ICWA. Other tribes that you've worked with in the past, other tribes in Nebraska can help identify qualified expert witnesses. Other tribes as QEWs is also on that priority preference list. And so if you've attempted to contact the Indian Child's Tribe, please feel free to contact other tribes in Nebraska so that at least an understanding of tribal cultures is there. You can also look at other tribes located in the surrounding areas of where the tribe is located. Just as for an example, I know that there are a bunch. I want to say like 15 or 16 different Sioux tribes. They are related, I believe, are closely located. And so trying to look for other tribes close in proximity to that tribe. And I will say Nebraska DHHS Native American Program, their team is also connected and has a great network to help find qualified expert witnesses. And I apologize to Amanda Doctor and Jackie Glestein and Allison Hoover for the potential inundation of emails into their inbox. But there's many ways to help locate a QEW. So when do we need a QEW? Here's the short answer: foster care placement and TPR. I will say as well that foster care placement, like I said, this is specifically for child welfare 3A petitions. However, it applies to civil guardianships as well. Civil guardianships and private adoptions under 25 USC 1903 sub 1 high. So, but for foster care placements or termination of parental rights. That's a short answer. Here's a long answer. So this is my very simplified timeline of a 3A case. The highlighted or bolded is where you'll need qualified expert witness testimony. I understand that 8 days is not a lot of time. There are nuances to this as well. So I will also say that if the qualified expert witness is not necessary for emergency removals. So you'll need them at protective custody going back. This emergency removal can be done without a qualified expert witness. It is after that emergency removal at the protective custody hearing where we're gonna need that QEW testimony. So ICWA does not prevent emergency removals of Indian children. Emergency removals are defined in the statute as well as in the regulations. If it's to prevent imminent physical damage or harm to the child, emergency removals terminate, however, when such a removal is no longer necessary to prevent imminent damage. So at that protective custody hearing, that has to happen statutorily, I believe 8 days, 8 to 10 days after. And the federal regulations say that the child is immediately threatened with harm, or if there's serious ongoing abuse, reason to fear an imminent reoccurrence. So here are some nuances that will impact a protective custody hearing. If you have reason to know that the child is ICWA applicable or has the potential to be ICWA applicable, if there is that reason to know, you have to act as if the Indian Child Welfare Act applies until an ICWA applicability is determined, which means that you have to send notice. And that notice must be by registered mail with a return receipt to the Indian parent and custodian, the child's Indian tribe, and the Bureau of Indian Affairs. So this means that you'll have an additional 10 to 30 days granted for that protective custody hearing so that you can act as if this is an Indian child. So foster care placement, no foster care placement or termination of parental rights proceedings shall be held until at least 10 days after the receipt of notice by the parent or Indian custodian and the tribe or secretary, so BIA, provided that the parent or Indian custodian or the tribe shall upon request be granted up to 20 additional days to prep for such proceedings. So you can request a continuance for a protective custody hearing for up to 10 days after you receive that registered return receipt. And then the tribe or the parents can request an additional 20 days so that they can prep and help. In any event, I'm not sure that this has happened recently, but they can also prepare a qualified expert witness that could of their own. So I know that there is initially, it looks like a short window, but there can be a continuance of 10 to 30 days. And this is why it's important to have that relationship with the tribe so that you can work on making sure that that qualified expert witness is ready for those protective custody hearings. Okay, so we are kind of flying through this, guys. So I'm sure there'll be plenty of time for questions, I hope, because I do see that there are some, but I haven't looked at them. So what should this testimony contain? So this is a statute, and it says, I've read it before, but that for protective custody, by clear and convincing evidence to include testimony of qualified expert witness, that the continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical damage. And that is obviously the burden of proof is different for TPR, but that testimony will include that testimony is the same for TPR and protective custody. And this is what the guidelines say. That expert testimony presented to state court should reflect and be informed by those cultural and social standards. This ensures that relevant cultural information is provided to the court and that the expert testimony is contextualized within the tribe's social and cultural standards. Thus, the question of whether the continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child is one that should be examined in the context of the prevailing cultural and social standards of the Indian child's tribe. So, all that to say that the contents of the QEW should answer the question of whether or not continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. And any questions regarding social, cultural, child rearing practices of the Indian child's tribe that would impact the decision and opinion of the court on whether or not the continued custody of the child will result in of the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. I will also reiterate, I also say that a qualified expert witness is not generally legally trained. I know that it is common for the qualified expert witness to be asked on issues regarding active efforts and issues regarding placement, especially placement preferences. It is outside the scope of a qualified expert witness to testify to active efforts into placement. However, if they feel comfortable testifying to that, it can be asked, but I will say it is it is outside the scope of the QEW to testify as to those two things. That is something that the active effort specifically is something that the caseworker or the IA worker should be testifying to, as they were the ones providing those active efforts. So we've got 20 minutes.
We do have a few questions in the chat.
I see that.
The first one is, does the 52-day average difference in time that Indian children spend in placement as compared to other children have any relation to the process of notifying a tribe of potential ICWA application and obtaining a QEW?
So trying to answer that question is difficult. There's a lot of reasons why that could be affected. I will say I don't think that it would be 52 days. You don't have 52 days to get a qualified expert witness. You have just the extended 10 to 32. So I'm not certain that is the exact reason. There's a lot of factors that would play into that.
And then there were a few comments about the Court of Appeals case, In Re Interest of Cameron L. and David L. The first is that a petition for further review to the Supreme Court has been filed. And then as far as Lancaster County, it seems like there really isn't a list of certified experts for Lancaster Juvenile Court.
That's good to hear. I will say I am working with the 4 Nebraska headquartered tribes, and I'm going to reach out to ICWA. I know that Teresa has tried working with me on this as well, to NICWA, to gather a list of qualified expert witnesses that the tribe has by resolution, by tribal council resolution, so essentially by tribal law, passed off as a qualified expert witness. But it is so important to have that relationship with the tribal representative and the tribal attorney or whoever is in charge of their ICWA department, so that you can meet one of those other preferences, those higher preferences under the Nebraska ICWA. Are there any other questions?
Yep. Is QEW testimony needed in a 3A case at the point of motioning for guardianship as a permanency plan, if already done at the protective custody hearing?
I will say that it does include under. Let me try and find. I have some notes on this. It does include guardianship. So foster care placement definition under 25 USC 1903 says that child custody proceedings and include foster care placement, which shall mean any action removing an Indian child from its parent or Indian custodian for temporary placement in a foster home or institution or the home of a guardian or conservator where the parent or Indian custodian cannot have the child returned upon demand, but where parental rights have not been terminated. So under the federal statute and under those definitions, I would say that a guardianship hearing would need to have a QEW testimony. I wanted to address this too. I know that some jurisdictions allow for qualified expert witness affidavits as opposed to qualified expert witness live testimony. The only time, and I can only speak for the Omaha tribe because that's the only tribe that I represent, but the only time that I feel like that would be acceptable is if it is an uncontested protective custody hearing where parents and all parties involved are not contesting the protective custody. It's just a matter of being able to cross-examine witnesses. And I just wanted to point that out, that affidavits, in my opinion, should only be used when it's an uncontested hearing.
Okay, the next question is a QEW required at the ICWA hearing, even if the case is a voluntary relinquishment for adoption?
Yes. Yeah, so it applies to private adoptions as well, voluntary or involuntary.
The next is, what were the two things that were outside the scope? I think that means outside the scope of the QEW's ability to testify to.
It was the active efforts. And these are just two of the things that I've seen asked of the QEW that are outside the scope of a QEW testimony. So one would be active efforts. Especially, I've had cases where the qualified expert witness is given access to those documents that are provided by the state, the affidavit, and whatever else the state decides to give the qualified expert witness those documents that they can reveal. It's hard without listening to testimony, or at least getting documents that provide a list and details of what active efforts have been provided for a qualified expert witness to testify as to that. I just don't think that a lot of times they have enough information to testify to that. Also, it's unnecessary because it's not listed specifically in the statute, and there's not that I've found case law that requires that active efforts or placement preferences be testified to by the qualified expert witness. If they feel comfortable doing so, I mean, sure, but a party can't object to those questions as it would be outside the scope of their testimony pursuant to the federal regulations and the statute.
Got it. Okay, the next question is an expert required at a disposition hearing, not for the efforts, but to support continued out-of-home placement at that point of the case? There's a line of thought that such expert opinion is still necessary at that hearing.
I don't believe so. I think once the child is in foster care, once the department has custody of that child and they're outside the Indian custodian or parental home, that has been determined.
Okay. The last one we have in the Q&A is, why is QEW testimony or an affidavit required if a parent consents to a guardianship or out-of-home placement? Does ICWA prohibit parents from being able to voluntarily choose to place their children in a guardianship or out of home?
Well, here's the thing. The tribe has an interest in these children because they are Indian children. ICWA applies to children who are eligible for enrollment or already enrolled in the tribe. And the tribe has an interest in these children because they have a political relationship with these children. They are either enrolled citizens of a sovereign nation or they're eligible for enrollment. So they have all of those rights and responsibilities that a citizen would have for that tribe. And because of that, the parent may not object to maybe an uncontested guardianship or or a voluntary adoption. However, this child is also a member or eligible for membership in a sovereign nation that has an interest in these children. So it is a tribe's right to the provisions under ICWA or even voluntary adoptions and guardianships. So, and I will say this as well, and it is not always the case. And it could be, that the guardianship or adoption is happening within family members and that kind of thing as well. But there are certain times where the law is there to protect the children from being unreasonably unreasonably removed from their families. And it is just an added layer of protection to make sure that what is being done in this legal process is actually something that the parent wants to do. It hasn't been my case, and but I have heard of a case where it was going to be a voluntary adoption, and the tribe intervened, and they just wanted to make sure that this parent was doing this for the right reasons. And the tribe's representative found out that the parent was doing this seemingly, voluntarily, but that they had a lot of reservations about everything. And so it's just an added layer of protection to make sure that the tribe's children are being protected from unnecessary removal, whether that be voluntary or not.
If a parent says yes, he or she is Indian but not enrolled in a tribe, is the child under ICWA then?
That is, well, if the parent is not enrolled.
Yes, says that they're Indian but not enrolled.
Well, if they're not enrolled, then the child would not be eligible for ICWA because the parent has to be enrolled in that child's tribe, or in a tribe, I should say. However, I will say this: if it is just a matter of filling out paperwork, filling out an enrollment application, I would hesitate to have an ICWA applicability determination hearing say that the child is not applicable for ICWA. It is a procedural technical matter that can be remedied quickly if need be.
And to clarify, does the statute say membership or does it specify enrollment needed?
Membership.
Okay. Placement is always an issue until the case is complete. If a change of placement is sought that is not the parent or custodian, is a QEW needed?
Can you read that again?
Yeah, placement is always an issue until the case is complete. If a change of placement is sought that is not the parent or custodian, is a QEW needed?
No. So a QEW, the protective custody hearing, or QEWs don't specify as to where the children will be placed. It is just that the children are placed out of the home. And so if it's for the benefit and safety of the child to be placed in a different foster home, or if they're moving from a foster home to a family member, the QEW has already testified as to that child being outside the home.
Are QEWs subject to sequestration orders just like other witnesses if requested?
That I would have to look into more. I don't know the answer to that question off my head.
What if the state wants to remove legal custody from the parent and place with the state, but leave the child physically placed with the parent? Would they need a QEW testimony to remove legal custody?
To remove legal custody? I don't believe so. I think it's physical custody. If the child is outside the parental or Indian custodian home.
And Pat Caraher, I might unmute you because I think you might have had an appeal that involved this issue. So if I can unmute you and if you want to say anything, or Tracy.
Go for it.
Pat's mic is open now.
So I don't know if you can hear me. I do think one of those Shayla H cases from about 10, 12 years ago talked about legal custody, but it was not the holding of the decision. It was just kind of dicta, and we're never real clear on exactly what it meant. We felt like, to be safe, you would want to have a QEW if the state was removing legal custody. But again, that was not the actual holding of the case. That wasn't the point of the case. And I'd have to go back and read exactly what the language was. But I do think there's an issue there.
Thank you for that. Next question is, if the parent who is enrolled does not want the tribe involved, do they have a choice?
No. The tribe has a right to be involved in any case regarding an Indian child of the tribes. So by rights, there's no legal objection to having a tribe intervene.
Could you give the name of the case with the Gorsuch opinion you recommended reading again?
It's Brackeen v. Holland. It came out last year, June of last year. It's Gorsuch's concurring opinion. Amy Coney Barrett wrote the opinion. Her opinion is only 13 pages and doesn't touch a lot of the legislative history that Neil Gorsuch's concurring opinion would touch on.
So we have about 4 minutes left. If there are any other lingering questions, go ahead and keep using the Q&A.
Alexis, several people have asked to have copies of the slides. Are you willing to share those?
Yeah. Copies of the slides are great.
Okay. I'll post them to the YouTube recording when I get that up.
All right. Thanks, Tracy. Well, Tracy, any more questions? If not, whoops, here, my email address is right here at the bottom. Feel free to email me any questions. More than happy to answer them if any comes up.
Great. And I did put the CLA activity ID in the chat if folks want to copy and paste that. We just want to thank everybody for spending their lunch hour with us, and especially Alexis for being always a treasure trove of knowledge. So thank you.
Thank you, everyone.
All right. Yeah, I don't think there are any more questions, so I'll end the webinar. Thanks. Thanks, Lexi.
Thank you.
Bye.